Let's go on the record, the hour of recess having expired. For the record, again, today is Thursday, September 8th. We are in the middle of the Evergy Metro and Evergy West general rate cases. On our agenda for this afternoon, we will be revisiting an issue raised this morning on the admission of an exhibit, and then we will be moving to street lighting, and that is issue Roman numeral XLIII, which I believe is 43. Mr. Kleiser, would you lead us off?
Yes, if I may. I'm going to attempt to explain where I believe the situation currently stands, and I invite other parties to correct me if they take a different position. But as my understanding is, you, Your Honor, offered a question from the bench during the examination of Ms. Messamore asking for a definition of the extended value basis. Upon redirect, the company moved to introduce the exhibit, I believe it's been pre-marked 137, which is the 2017 annual update excerpt. I objected on the basis primarily that the 60-page document, in my opinion, does not necessarily relate to the question that was posed and that I hadn't had an ability to cross her on other elements of the document. It is my belief that there are portions of the document that Evergy may rely on in support of its underlying argument regarding the prudence of Sibley that is unrelated to the question that was posed by the bench. I have prepared cross-examination on that topic related to the prudence of Sibley that might be gleaned from this document if that was the nature for which it was being offered. However, if the Commission accepts the document solely and exclusively for the purposes of defining extended value basis and not for any attempt to address the prudency of the Sibley decision, then I have no need for cross. If, on the other hand, the Commission wishes to accept the document to address the prudency of the Sibley decision, then I would like to be able to cross Ms. Messamore briefly on that topic as it relates to this document, even though that was not the basis for which the document was offered based on Commission questions.
If I am hearing this correctly, I am going to look to Evergy Council. If they affirm that they are only going to use it for the purpose laid out by Mr. Kleiser, then the exhibit is admitted and we'll move on. If they answer the negative, that they might use this report for other citation, we'll go ahead and ask Ms. Messamore to re-enter the witness stand.
Judge, I do have a response. First of all, unless I gave Mr. Kleiser something that I didn't intend to, the Exhibit 138 is only 20 pages long. It consists, the first part is like it's the cover page, and then it goes through, I think, page 7. And then it jumps to page 41 and then goes to 54. So it really is a relatively brief document. I should also say, Judge, it's marked highly confidential. It apparently was back in June of 2017. It no longer is. I think that when you asked about the expected value of Sibley, that was a broad enough question to indicate its value as an existing and as a retired unit, and its value, as either being operational or not part of the system. And then you also asked a question about about an upgrade in 2040, which led to a brief discussion in terms of the why did it have a life as of 2040. I think those questions are broad enough to allow this document, which was discussed in Ms. Messamore's testimony, to come into evidence, and I'm certainly open to having Mr. Kleiser ask Ms. Messamore some questions. So respectfully, I'm not going to accept Mr. Kleiser's offer of limiting the use of this document because I think it is informative to the issues that are before the Commission.
Okay, then we will call Ms. Messamore back to the stand, please. As she has already been sworn in.
Just in case, in order to make sure that this is clean, my cross questions relate to the discussion of the prudency of the decision to retire Sibley, which is the reason for which I believe this is being offered. They will not directly relate to the question posed by the bench regarding the definition of an expected value basis.
I'm fine with that.
Thank you.
That makes sense to me, explaining for the parties that Ms. Messmore was originally here for Sibley. Since my question seems to have opened up a door for the company to walk through, if you want to follow them, I understand.
Judge, and may I just ask, has the exhibit been admitted at this point?
It will be. Any objections to the admission?
Just for the sake of the record, I'll renew my objection, but I understand the commission's decision.
No, not a problem. I want to make sure that you have that opportunity. Overruled, the Exhibit 138 is admitted. I will note for the record, as Mr. Zobrist pointed out, the exhibit itself says highly confidential, and that was applicable in 2017 and is not currently applicable to this exhibit, period. Yes, Mr. Gleiser, go ahead.
Good afternoon, Ms. Messamore. Did I pronounce your name correctly?
Yes,
Thank you. To begin with, you began working for Evergy after the creation of this document, correct?
that's correct.
And you were not directly involved in the creation of this document, correct?
Correct.
Have you reviewed the surrebuttal testimony of Dr. Jeff Mark?
Yes, I have.
I'd like to turn your attention to the attachment to Dr. Mark's surrebuttal testimony marked GM6. I have courtesy copies for counsel and the bench, which I will hand out. I sure hope I have a second copy. No, I got it. And for the record, I'm not asking this to be pre-marked as an exhibit because, again, it is an attachment to Dr. Mark's surrebuttal testimony, which has already been offered and accepted. Ms. Messamore, you would agree with me that this document is the OPC's response to the 2017 Integrated Resource Plan update, the document which this small re-cross-examination is concerning, correct?
Yes.
And if I could direct your attention to page 3.
Mr. Kleiser, is that numbered page 3 or physical page 3?
I am working off the numerals in the document itself. It should be, the page should have dynamic SPP market.
It's the second, page 3.
The second, page 3.
I see what the problem is. Page 3 of the attached memorandum. I apologize. I was not clear. You would agree with me that the OPC raised concerns related to the 2017 IRP annual update filed by the company, correct?
I would say they filed comments, which is the language in an annual update proceeding.
And one of those comments concerned the dynamic nature of the SPP market as outlined on page 3 of the attached memorandum.
That's correct.
And on page 4, if you'll permit me, beginning at the first full paragraph, it reads, in short, if GMO's IRP modeling suggests retiring significant amounts of baseload generation prematurely, it's prudent.
I'm sorry, just read a little bit slower, please.
Of course, I apologize. In short, if GMO's IRP modeling suggests retiring significant amounts of baseload generation prematurely is prudent, won't other SPP members' modeling show similar results? Under that scenario, a near-term future where excess SPP reserve margins are erased entirely appears plausible. You would agree with me that the OPC was raising a concern that the modeling performed by Evergy did not take into consideration the fact that other entities in the SPP market would also make similar retirements to those being proposed by Evergy, correct?
That is what the paragraph says, yes.
And I'm not going to read this because it's already in the record, but if you would, for yourself, just read the 2 italicized portions concerning the DR response sent by, or rather DR the data request sent by OPC and the company's response, you would agree with me that the company did not, in its 2017 Integrated Resource Plan, include the same coal retirements in the SPP 2017 ITP 10 report, correct? Based on the response by Evergy?
That's what that says, yes.
Turning back to page 1 of the memorandum. You would agree with me that the memorandum is dated July 30th, 2017?
Yes.
And while there has been certain disagreement as to the exact date at which Sibley was retired, you would agree with me that it did not occur until at least 2018.
That's correct.
You would agree with me, therefore, that the concerns raised by the OPC in this document occurred, or were raised, rather, before the retirement of Sibley, correct?
Yes.
And if I were to proffer to you the definition of hindsight being something akin to a decision made after the fact, would you agree with me that that's at least a workable definition of hindsight?
Could you say it again?
I'm going to pull out my phone and give you a definition. Even better. Let's use as a definition of hindsight the following. Understanding of a situation or event only after it has happened or developed. Can you agree with me that that's a workable definition of hindsight?
According to the internet, yes.
Would you agree with me that if the OPC raised its concerns prior to the retirement of Sibley, these concerns cannot by definition be considered hindsight analysis?
Objection, that calls for a legal conclusion, Judge.
Yeah. Can you rephrase it?
What part of that was calling for legal conclusion, just to be clear?
Tell me your question again. Would you?
I'm not going to repeat the exact question because I
Right.
can't recall it, but in an effort to paraphrase, my question, I believe, was you would agree with me that if the OPC raised its concerns prior to the decision to retire Sibley, it cannot qualify as hindsight analysis.
Here's my problem with it is hindsight is a term of art that is used in a, I forget the year, case that describes the commission's guidelines on prudence finding. So it is a legal conclusion by asking her if by definition the date on this report, and I think there's some in-between dots, but if that by definition meets that term of hindsight.
Let me try and rephrase, and we'll
Okay.
see if that resolves the issue. You would agree with me that a party making a decision based on this information before the decision to retire Sibley occurred would not be making its decision based on hindsight.
Judge, I'm going to object because it not only is trying to have this witness define an element of the prudence standard, which the commission adopted in, I think, the Union Electric case in 1983 or 1985, plus at this point it's argumentative, and I think public counsel can certainly argue this in their brief. It's got the dates. This document is already into evidence, and I think questioning the witness on this point is objectionable.
If I may respond, I believe that several of Evergy's witnesses have already provided testimony in this case that the OPC was operating on hindsight analysis. So to the degree that there's a question regarding legal analysis, it's already in the testimony.
That may be true, Your Honor, but those witnesses were especially called to give expert opinions with regard to the prudence test. This witness is not. She is a factual witness.
How is a witness providing factual basis for a legal test?
I'm going to go ahead and rule. Mr. Kleiser, I'm going to overrule you, but I would gently point out that the bench is certainly aware
The point
of
has
the
been made.
date.
Is that what you're saying?
I wouldn't put that fine of a point on it, but yes. I also would tend to agree with Mr. Zobrist. This may not be quite the right witness for that. I understand we're running a little out of time, but I certainly understand the point you're going after. Go ahead. Well, and if you can rephrase, I think that is still an open avenue.
The information contained in this document was filed before the commission, which was filed before the commission, would be information that the company had in its possession at the time it made the decision to retire Sibley, correct?
Yes, as well as the parallel filing of a special contemporary issue that the OPC made in the 2018 triennial case to the same effect.
I think that's going to be sufficient for me. Thank you.
Excellent, thank you, Mr. Kleiser. Let me check where we were at. We had recalled Ms. Messamore for any questions. Given where we're at, I'm certainly going to go back to redirect, but I do want to offer up a recross to anyone else before we get to redirect. I would note for the record, staff declines their opportunity. Evergy.
I don't have any more questions, Judge.
Ms. Messamore, thank you very much. You are excused. As Ms. Messamore takes her leave, I'll make a quick announcement. We will be now transitioning to the street lighting issue. By my count, I have 3 witnesses, including one of staff, who is available or is going to be here.
She is available and actually I think in here, so both.
I totally couldn't see her. Never mind.
She and I apologize for any confusion and how staff offered Ms. Lange to the parties in the commission, but Ms. Lange's overall testimony on rate design and class cost of service kind of subsumed the St. Joe street lighting issues, and so she did not have any separate testimony on it, but just in case the commissioners or the bench had any informational questions or tariff-related questions, we thought we would offer her for anything you might need from her, but my understanding is that the parties may not have questions for her.
Understood. Then I will go through our 2 street lighting witnesses, and then I will ask if any commissioners or parties would have questions for Ms. Lange before we bring her up.
Yes, that works for me. Thank you very much.
Evergy, I believe this is your witness first. We need a minute.
Are we doing mini openings?
Oh, it's almost like
we don't have to, but
let's go ahead and I'll offer the opportunity. Any mini openings?
to do one, Bill. Okay, then I'll do one. I think I'm first.
Let's go ahead and we'll allow the company to go first. Mr. Steiner. Please go ahead.
All right, good afternoon. May it please the commission. In this issue, the city of St. Joseph seeks to change Evergy, Missouri West's existing tariffs. They want the company to accept developer-installed streetlights as part of the company's streetlight asset inventory. This kind of has a past to it. In the olden days, St. Joseph was the only area in the West system that permitted developer-installed streetlights to be included in the company's rate base. They were included at a value of 0 cost. And this exception for St. Joseph was discontinued by the commission-approved tariffs many years ago. Under the company's current tariffs, the city can meet its street lighting needs by either utilizing streetlights installed by the company or receiving energy service from the company and installing and maintaining its own streetlight system. The city's proposed change to the existing tariffs would require the company to add resources, add personnel, to determine if the developer-installed streetlights meet and continue to meet the company's standards for streetlights. Would also require the company to account for the streetlight facilities in its accounting system. Mr. Brad Lutz will explain that under the current system, the company is responsible for company-owned streetlights, but does not need to inspect developer or city-installed streetlights for adherence to electrical standards or for maintenance, as they are part of the city-owned streetlight system. This tariff arrangement has worked well for all other municipalities in the company's territories and should not be changed for the benefit of one city. There's a separate related issue. The city also questions the inclusion of streetlight maintenance charges for company-owned streetlights that's in the company's current tariff. The company believes the charges are appropriate since the purpose of these charges is to cover the maintenance of the streetlights. If they get hit by a car, if wiring goes out, these things are long-lived assets. They do require maintenance. And again, as explained by Mr. Lutz in his testimony, those costs are not accounted for anywhere else in the tariff rate paid by the city. So the company asks that the tariffs remain as they are. Thank you.
Thank you, Mr. Steiner. Any commissioner questions? Hearing none, the bench doesn't have any questions. Thank you, sir. Mr. Steinmeier, please come on up, give us your opening statement. And I would also like to note for the record and ask Mr. Steinmeier to enter his appearance so that we have it official.
Yes, thank you, Your Honor. Please let the record reflect the appearance of William D. Steinmeier, PC, 2031 Tower Drive, Jefferson City, Missouri, 65109, appearing on behalf of the City of St. Joseph, Missouri.
Excellent. The floor is yours, sir.
May it please the Commission. Your Honor, Mr. Chairman, members of the Commission, the City of St. Joseph brings a unique issue to the case today in the hope of restoring a practice that it employed successfully for at least 2 decades before it quietly disappeared in the 2016 rate case of KCP&L Greater Missouri Operations, which is now Evergy, Missouri West. That practice was that the city, in the exercise of its authority as a charter city, required that developers and city contractors be responsible for the construction of new infrastructure, including streetlights. The developer or contractor would pay for all that infrastructure and post a maintenance bond for any work needed on streetlights for 2 years. These capital costs became costs of the developer to recoup from the development project, or of the contractor being paid from a public funding mechanism such as the Capital Improvement Sales Tax or grant funding. If undergrounding of power lines to a streetlight was required, the cost of undergrounding was borne by the developer or contractor. This was true of breakaway bases, rock removal, or other trenching or boring as well. At the end of the project, Evergy would inspect the streetlights to ensure compliance with appropriate standards and would accept ownership of the streetlights. When the company sought to consolidate the tariffs of the former St. Joseph Light and Power, SJLP, and the former Missouri Public Service Company, or MPS, in its 2016 rate case, it decided it would like to simplify its streetlight practices. It did so in that case by quietly eliminating this long-standing practice with the City of St. Joseph. Based on its revised Sheet 150, which was approved in that case, Evergy West now asserts that the company, and only the company, may install streetlights within its service territory. This only became clear to the city in 2018 when the company made an issue of it regarding a development or two, then in progress, within the City of St. Joseph. The main reason this matter is so important to the City of St. Joseph is that the company's application of its revised Tariff 150 shifts what used to be capital costs of the city, borne by developers or contractors, to operating costs of the city, paid directly by the city's taxpayers when the city pays its electric bill to Evergy. This places new strain on the city's budget and places a significant burden on city resources that would otherwise be used for street maintenance, police protection, fire protection, and other critical operations the public relies on the city to perform. In addition, in its electric rates in Tariff Sheet 150, Evergy also charges the city extra for undergrounding, service extensions, breakaway bases, rock removal, or other specialized trenching, for the installation of underground service, and for metal poles instead of wood poles. Those become ongoing monthly charges to the city, whereas previously a developer or city contractor had paid for those items as a capital cost of the project. The city of St. Joseph believes it is unfair for the city to have to pay for those capital costs in its monthly electric rates simply because the company requires that it build all new streetlights. Under the exercise of the city's proper legal authority, it can require those capital costs to be incurred by the developer or the city's contractor. And for the many projects completed before Evergy's most recent policy and practice, where ownership of streetlights has been accepted by the company after being built by the developer or contractor, it is unfair for the city to then be paying for undergrounding and breakaway bases again through its tariff rates. The City of St. Joseph proposes that language be added to the company's street lighting tariff that allows the historic practice used by the city and the company before the 2016 rate case. The city also proposes that language be added to that tariff that prohibits the company from charging in extra charges for breakaway bases, undergrounding, metal poles, and other costs that were already absorbed by a city contractor or city-approved developer. The city urges the Commission to carefully review all the testimony on this issue and thanks you very much for your consideration of this issue of significance to the City of St. Joseph. Thank you, Your Honor.
Thank you, Mr. Steinmeier. Any commissioner questions for Mr. Steinmeier? Hearing none, thank you, sir. Let's go ahead and move to our witnesses, Mr. Lutz. As Mr. Lutz makes his way, I will remind him he has already been sworn in, and that is still applicable. Evergy, your witness.
Your Honor, all of Mr. Lutz's testimony has previously been admitted, so I would tender him for cross-examination.
St. Joseph.
Just a moment, please, Your Honor. I had thought the city would be going first. So. Good afternoon, Mr. Lutz.
Good afternoon, Mr. Steinmeier.
I hope you won't be offended if I remain seated while I ask you some questions.
Not at all.
Oh. Your Honor, we caused to be emailed last evening 3 hearing exhibits. I'm about to ask Mr. Lutz about one of those. Do I need to present the reporter with a paper copy of that.
No, if you could give Mr. Lutz a copy to refer to and the other council in the room, if you happen to have a copy for me, that would be great, but the priority is Mr. Lutz and then council.
Thank you.
So much for remaining seated. Okay, Mr. Lutz, this has been pre-marked Exhibit 852. May I ask if you recognize this as the proposed tariff of Evergy in this case on street lighting?
Yes, actually, there are two tariffs in this packet, one being the municipal street lighting service, sheet number 150 and its subsequent pages, and then municipal off-peak lighting, sheet 151.
Yes, exactly, thank you. And that is by design. So as this tariff is applied to an individual streetlight in the city of St. Joseph, first, you would look at what type of light it is on the first page, whether it comes under 1.0, 2.0, or 3.0, and then the appropriate size. So let's say it was a 2.1 to street luminaire on a wood pole, 5,000 lumen LED, 16 kilowatt hours. You would bill St. Joseph $14.09 for that.
That is correct.
Then turning to to the next page, which is actually 150.1. If any of the equipment 4.1 through 4.5 was attendant to that pole, you would add to that monthly rate the appropriate dollar amount. So if it's a metal pole, it would be the page one amount plus $5.15.
That is correct.
And if it took undergrounding to get there, which I think it would with a metal pole, then it's another $4.84 for that pole.
That is correct.
And if rock had to be removed, it's another $19.36 for that pole
That is correct.
per month.
Correct.
And if it was a light on a withdrawn. Then let me please refer you to the company's response to the city's data request 2.2. which will be Exhibit 853. Mr. Lutz, can you identify this document?
Yes, it is a data request response, City of St. Joseph request number 2-2, providing a listing of the developer installed lights in our records since 2017.
And according to the information on this response, on this exhibit, of these 61 streetlights that Evergy identified, would I be correct in saying that 31 of them had breakaway bases? Or about, or slightly more than half?
I'll accept your math, yes.
If you find it incorrect, please say so in the brief, but I'm pretty sure that's correct. And that all 61 required undergrounding?
Yes,
So the city of St. Joseph is being charged extra for undergrounding and breakaway bases under Tariff 150 for these streetlights.
I'm going to object to the form of the question that it extra, I'm not sure what he means there.
Well, so in addition to the charges on sheet 150, the company charges the city of St. Joseph charges on tariff 150.1.
yes, and I would say it would be our position that these services are in place at those locations, and that additional charge is justified for that service received.
And on sheet 150.2, there's also an item 5.0, special mounting heights, and if there are streetlights that are on unusually tall poles,
Yes,
they pay those additional amounts.
yes.
Your Honor, I would offer Exhibits 852 and 853 into evidence.
You've heard the motion by Mr. Steinmeier, the admission of Exhibits 852 and 853, 852 being the revised tariff sheets, and 853 being the data request and response. Any objections? No objection? Hold on just a minute.
I don't have an objection. I was just curious to know what St. Joe's exhibit numbers were, and I didn't want them to be confused with Evergy exhibits because of the numbering system.
No, and I believe I forgot to issue St. Joe's exhibit numbers, and I believe Mr.
In the- in-
Steinmeier,
In the first instance, that is correct, the order that came out giving everybody else exhibit numbers.
and then we resolved that. I issued an order later.
A special order, and we got 850 through 899, I believe, assigned.
I apologize for the confusion. I
No,
have
you're right.
objections.
I divided the later ones into 50 brackets, so I would always remain under 1,000. A little behind-the-scenes baseball for how judges do stuff. Okay. No objections. Exhibits are admitted. That was 852 and 853.
Yes,
Mr.
Your Honor.
Steinmeier, go ahead.
Lutz, let me refer you to your rebuttal testimony on page 12.
I'm there.
At line 3, question, Mr. Carter questions the inclusion of charges for undergrounding and breakaway bases. Are these charges appropriate for streetlights installed by developers? Answer, yes. The purpose of including these charges is to cover the ongoing maintenance of the underground conductors and breakaway bases. These costs are not accounted for elsewhere in the rate paid by the city. Is that a correct reading?
It is.
Returning to Exhibit 853, the data request,
Yes, sir.
2.2. No, I'm sorry. Back to the tariff sheets, Exhibit 852.
Okay, I'm there.
On sheet 150.1, does, under the item rate, optional equipment, MOMLL 4.0, does it state optional equipment, colon, the following rates for optional equipment may be added to the rate for basic installation?
Yes, sir.
Under 4.1, metal pole instead of wood pole, new installations are available with underground service only. Correct reading?
Correct reading.
4.3 refers to underground service extension,
Yes.
there's concrete.
Mm-hmm.
So that would be an extension of some place that didn't have service to create something that had service. 4.4 refers to rock removal or other specialized trenching/boring for installation of underground service, correct?
Correct.
And 4.5 says that a breakaway base is, quote, available with underground service on metal poles only, close quote. You're nodding affirmatively.
I was waiting for a question, I'm sorry. But yes, I agree that that is the reading.
That's what it says.
Yes, correct.
And section 5.0 on sheet 150.2 refers to charges that, quote, may be added to the rate for new basic installations listed in section 1.0 or 2.0, correct?
Correct.
So isn't it correct that these charges are for installation of new facilities? not for ongoing maintenance?
No, I would disagree with that reading.
Isn't it clear that at the very least, those charges include installation costs?
Certainly include installation cost. Yes, I would agree with that. Let's see. The wording that you're observing around new is more about establishing the conditions where those terms would be applied. For example, contrasting new versus retrofit. Like if you were installing a light on an existing pole or in some kind of an existing manner. So the words new, for example, is used in contrast to existing, not necessarily meant to limit it in some way or to isolate those costs to installation only. I don't read these as being installation only. The other factor I would offer is that they're monthly rates, an ongoing monthly charge. And in my reading, if this were an installation event or installation charge, it would be more of a one-time cost or something of that nature, as opposed to something that would perpetuate monthly. So in my reading, there's a few signs that indicate to me that this is beyond just installation cost only.
What is the installation cost for a new streetlight?
For a new streetlight, it's difficult for me to say offhand because of the number of conditions that would go into that number. You know, where it's located, you understand installation of equipment. But all of those factors could change this number. But as a rule of thumb, I would offer it's about $3,800 roughly to install a streetlight pole, a metal streetlight pole. By the company. I guess I should also qualify that would be at our labor rates and our equipment rates and all of those components.
Very well. We've had a conversation in the last week, and in response to a data request, Evergy informed the city that the streetlights listed, the 61 streetlights listed in this exhibit 853 are in rate base.
Correct. We received a data request asking that, and we simply responded with almost like a yes/no answer. And then the conversation you're referring to was in my witness preparation for this hearing, I discovered or was made aware that the rate base was valued at $0 when it went into the books. And I wanted to make sure that you were aware of that.
And I want to make sure that the record reflects that accurately.
Okay.
Which is why I'm asking, and thank you for saving me from having to mark that data request response.
Okay.
So those streetlights are in rate base, if you look at a list, but they're actually valued at $0.
Yes, and maybe another nuance to that is that the phrase rate base in a way is referring also to just our plant account records. And so they are truly in the plant account records that are used to generate the rate base data that's used for the rate proceeding. So maybe that's a little bit of a clarification of the relationship between the entry in our books and how it applies to rate base in this case.
Thank you. I have one more exhibit that I just thought we ought to enter into the record because both you and Mr. Carter have referred to it in testimony. Can you please explain for the record, Mr. Lutz, what this Exhibit 854 is?
Yes. It is a letter from Dan Hegeman representing Evergy to Andy Clements, the Director of Public Works for the City of St. Joseph, on April 16th, 2020. And this letter is detailing the current tariff options available to the city with respect to some development at the Mitchell Woods Business Park and the shops of the North Village.
Thank you. Your Honor, I offer Exhibit 854 into evidence.
You've heard the motion. Are there any objections to the admission of the letter response by Evergy dated April 16th, 2020 as Exhibit 854? Hearing none, it is so admitted. Go ahead.
Now, Mr. Lutz, let me refer, and I'm getting close to the end if anybody wonders and is checking their clock. Let me refer to your rebuttal testimony on, starting on page 12 at line 8.
I am there.
Is it fair to summarize your testimony here as suggesting that if Evergy were to restore the arrangement that St. Joseph previously had with the company, it would have to offer that arrangement to all of Evergy West, all of Evergy, and probably in Kansas as well?
In short, yes. I mean, to begin, to have a provision limited to one customer is preferential, and we would probably want to avoid that. So at minimum, we would have to open it up to certain descriptions of customers. I think the city has offered some ideas there. But to be fair, I think that, you're going to find that there are other people that will try to fit into that or will, in subsequent proceedings, try to open that up more broadly. In the company's opinion, going and restoring this service will just be the first step in many that will happen over time for other cities to get this same kind of treatment simply because of the economics that you've described.
But it is your testimony that the city of St. Joseph was the only customer of Evergy West that employed that practice of having contractors or developers install streetlights at their expense and then turning them over to the company, correct?
Correct. I believe it to be born out of the relationship between the city and the St. Joseph Light and Power Company that predates Evergy. And it, in a sense, was pulled forward in time from that point.
And it is your testimony that no other municipality in any of Evergy's service areas used that practice previously?
Yes, I would further say they may not have been aware of it either. I am of the impression that this was handled somewhat through a special arrangement, special agreement type approach that would possibly not have been overtly detailed in the tariffs. I believe that the St. Joseph Light and Power tariffs may have included provisions that allowed these kind of agreements.
But wouldn't your concern about expansionism be diminished greatly if the city's proposal was limited to say, a charter city which before 2016 had a program in which streetlights installed by city contractors or city-approved developers at their expense became property of the company upon inspection and acceptance by the company?
I believe that that would help us in this proceeding, but I think that it would create an opening, it would create a justification for other cities of other classifications to approach the commission and find if they can expand that availability. Instead, I looked at the impact on the utility in our processes, and we've assessed that there are a couple options available to the city that have worked well for other municipalities, and we choose that is the approach that we would prefer, as opposed to trying to navigate a way of constraining future customers away from this developer-installed treatment.
Understood. But if the city's proposal were accepted by the commission and limited in the way I just described, any other changes would have to be brought in a different rate case by other people?
Correct. And I must offer too that I think that the company would have to take a pretty hard look at what it would take to reestablish that process, that infrastructure, if you will. The company is not the same company it was when St. Joseph Light and Power was interacting with the city. A lot has changed in that time, and we would have to make sure that the pricing and the approaches would remain equitable to all customers, that there was not some level of subsidy built into that proposal. But yeah, if the commission ordered us to do that, we would go through those steps for this proceeding.
Thank you, Mr. Lutz. You have anything else? No further questions, Your Honor.
Thank you, and we are on cross-examination of Mr. Lutz. That will take us to staff. And Mr. Kleiser for public counsel.
Originally, I didn't have anything, but sitting here, I had a question come to my mind, and I want a little bit of clarification. By the way, good afternoon, Mr. Lutz.
Good afternoon.
I think I heard you testify that the streetlights that were, I'm going to use gifted by the company, were booked at $0. I'm not sure if you want to use that term, gifted or not.
It's been used in testimony, so it's fair.
Okay, but you testified they're at $0 in plant?
Yes.
Do you know whether they're booked at an original cost of $0, or are they booked at original cost with a corresponding offset due to contributions in aid of construction that reduces net plant base to $0?
No, sir, I do not. My questioning was limited at determining if there was any kind of double collection within the rate-making process. I did not explore further.
Okay, I had a sneaking suspicion that was probably not going to be the right person to ask.
Yes.
And honestly, it's not so important, so I have no further questions. Thank you.
Thank you, Mr. Kleiser. That will bring us to commissioner questions. Are there any commissioner questions for Mr. Lutz?
No questions, Judge.
Thank you, Commissioner Holzman. The bench does have a couple questions.
Okay.
I want to make sure that I am following. All of the different tariff charges and fees that you were just discussing with Mr. Steinmeier, are those any different than any charges and fees applicable to any other of the company's customers?
No, the charges on 150 and 151 are applicable to all of Evergy, Missouri West customers.
You mentioned St. Joe Lighting Company.
Yeah, Light and Power Company,
Light and
yes,
Power.
sir.
That predates my time. I want to draw the conclusion that that was a city-owned utility?
No, it was an investor-owned utility.
Okay.
Served about 10 counties in northwest Missouri, with St. Joseph being the primary city of its service territory.
Okay.
It served all the way up into the Iowa border, kind of in that northwest corner. It was purchased by Utilicorp United that became Aquila, and that became GMO, the Greater Missouri Operations Company, and then that became Evergy, Missouri West.
I see. You testified to $3,800 to install a pole.
Correct.
Does that include the actual cost? Evergy went out and purchased a pole.
Yes, I believe that to be the full cost of installing a metal pole with an LED fixture and the breakaway bases and things that we're talking about here.
You said installing again, though. How much does the pole cost?
Oh, I don't have a breakdown
Okay.
of that
But it
available.
is a separate thing.
No, it's in that $3,800. The
A
3,000.
street light pole is seriously, I could go out and buy one for less than $3,800 and possibly have it installed?
Well, and remember, we're buying as a utility, so
Okay.
that would be much different pricing than you might pay at Home Depot, for example.
I was expecting a much higher price tag for the pole. Okay. Is the submitted tariffs that you were discussing with Mr. Steinmeier addressing municipal street lighting service and off-peak lighting service, are those based on a cost of service approach?
I would say yes.
How many street lights are in St. Joseph? And that that will certainly be a question for Mr. Carter, but just in case.
Let me see if I can, they're itemized by type. So I can at least give you, allow me a moment. Unless, Mr. Carter, do you have that? Okay, okay. Allow me a moment.
Please.
I have, for the LED lighting type, 6,503 lights. So we can say approximately 6,500.
Thank you. I wanted to get a sense of that compared to the 61 that were referenced in the letter.
Now, there are, just to be aware, that there are a few older light types that are not in this segment of the bill that are on another bill. They might be of high-pressure sodium or mercury vapor type, or not of street lighting type, but
I was more interested to get a scale
Yes.
of the 61 out of. Okay,
yes.
so this is thousands, if not perhaps over 10,000. Mr. Steinmeier, and I don't recall if it was in a question or his opening statement, he said that Evergy was the only company allowed to install street lights. By my reading of the tariff, it seems that the company does allow third parties or even cities to do their own. And then they have a separate rate, and that's that off-peak rate.
Correct. The 151 would allow others to do that installation. That is correct.
Is there anything stopping, but this seems to boil down to finances. Who's paying for the street lights, the developers or the company, and how does that monthly bill shake out? Is there anything stopping the city from passing on any of those charges? And I'm just now thinking this out loud, and these are monthly charges.
Correct. Correct. They're
Okay.
monthly charges. No, I don't think so, but if I recall the opening statements and the testimony of the city, it has also to do with the category of the cost in their own budgeting processes, capital versus maintenance, I think, where they have some concerns.
Accounting, I
Yes,
understand.
Yes.
My last question. I'm referring to Exhibit 854, which is the letter asking identify all streetlights gifted by the city. Okay.
Correct.
Under the bold response about the middle of the page, it reads, quote, available records are limited to 2017. End quote. Here's my question. The paragraph ends with a citation with reading that those streetlights are transferred from the city to Evergy, quote, in exchange for a maintenance-only rate, end quote. Mr. Steinmeier is stating that the tariff changed after 2016, and there wasn't any more of the deal that was available for St. Joseph. How are you granting a maintenance-only rate in 2017 and after? This
Yeah.
letter seems to imply to me that as of 2016, rates changed in the case, but Evergy's records only go back to 2017, and whoever wrote the letter checked and said, hey, those 61 street lights, they were given to us in exchange for a maintenance-only rate. Is there a maintenance-only rate in your tariff?
No.
What is a maintenance-only rate?
It attempts to strip out the equipment aspects of this all-in rate and provide only the maintenance and energy cost elements.
So without the tariff explicitly stating a grandfather clause, which I believe is what we were referencing earlier, the company has, in my interpretation is right, the company is saying as to these 61, and granted out of the 6,000 plus, but those 61, we're not going to charge you for the installation and all of that because those were gifted to us. We're just going to charge you, and then you started cutting off the stuff, so it's just the maintenance.
Yes.
Thank you. I don't have any other questions, but
Yeah,
we got to go through it.
you bet.
Okay, let's go back to recross-examination. Mr. Steinmeier. We did direct, cross, commission, bench, and now we go back to recross, and I believe it goes St. Joe staff, OPC.
No further questions, Your Honor. Thank you.
Staff?
Just very briefly, Good afternoon, Mr. Lutz. How you doing?
I'm good. Good afternoon.
Just to clarify, you were asked a question from the bench about if these are cost-based rates.
Yes.
Do you recall? Is it your understanding that based on the outcome of the remaining issues that have revenue requirement impact and pending commission approval of the stipulations, that these tariffs would be adjusted to reflect the commission-approved revenue requirement?
Certainly, whatever that might be, ultimately, yes.
Okay, thank you for that clarification.
Yes.
Okay, we'll move on. Public counsel.
No questions, thank you.
Redirect.
Thank you. Just a few. Mr. Lutz, let's start with the tariff, what was marked by the city as Exhibit 852. Do you have that?
I do.
So I believe you were asked some questions about sheet 150.1 under the term rate, optional equipment, comma, MOMLL. Do you see that?
I do.
What company costs are these charges designed to cover?
They are designed to cover the additional costs associated with the installation of these elements listed in 4.1 and 4.5, as they might be considered add-on or, say, premium type features on top of the rates on sheet 150. What we do in designing the rates is we have a standard approach that we model and then come up with that pricing. And then there are additional circumstances, if you will, or features that we have to account for. And those are covered in the Section 4 pricing.
So these charges apply to company-owned streetlights only, correct?
Correct.
They would not apply to the streetlights that were installed by a developer and owned by the city, correct?
Yeah, any city-owned equipment would not be subject to the 150 pricing.
So let's take an example, 4.3 undergrad service extension under concrete. How would that come to be for an existing pole? What would make the company have to do underground service for an existing pole, say, 10 years after this streetlight was installed?
Right. It's not uncommon for overhead facilities to be preferred to be underground. And that would be the example here, is that we maybe had a streetlight that was served with an overhead conductor that was later put either new or retrofit, to your example, underground.
Okay, let's go to Exhibit 853, which is the data request response.
I have it.
And just want to make sure it's clear, it's your understanding that this is a listing of city-owned streetlights, streetlights that were built by developers and gifted to Evergy.
Correct.
And it's your understanding that they are in the company's rate base, but at a value of 0. Is that correct?
Yes.
And you would believe that the company is not earning a return on those streetlights. Is that correct?
That is my understanding, yes.
Okay. Let's move on to the letter. I think it's been marked as 854.
I have it.
And you identified the letter sent to the city, and the letter explains that having the developer install lights, transfer ownership, and then transfer it over to the company, that is no longer available under the company's tariffs. Do you agree that that's part of what the letter says?
Correct.
Do you believe that the company notified the city of this change in policy as set forth in its tariffs earlier than the date of this letter?
I do, and we covered some of that in the testimony and laid that out. And definitely during some data request discovery, I was unable to provide some of those copies, but I do feel very comfortable that representatives of the company were in contact with representatives of the city at the time when we were doing these changes.
And that would have been what year approximately?
Going back to about 2018, I think was one of the more formal, and then there would have been events associated with the rate case in 2016. It's our normal practice that our representatives to the municipalities have exchanges with the cities during rate cases to discuss matters like this.
I think that's all I have. Thank you.
Thank you, Mr. Steiner. Mr. Lutz, you are excused. Thank you, sir. We will move on to our next witness. Mr. Steinmeier, please call your witness.
The City of St. Joseph calls Brian Carter to the stand. Yeah, take those.
Thank you, sir. If you would please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Your witness, go ahead.
Thank you, Your Honor. Before I move on, may I confirm that I offered Exhibit 854 and it was received in evidence?
Yes,
Thank you.
confirmed. I will need a motion for 850 and 851, which is Mr. Carter's testimony, but that'll come in time.
Coming soon. Please state your name and business address for the record.
I'm Brian Carter. My office address is City Hall, 1100 Frederick Avenue in St. Joseph, Missouri, and it's 64501.
And you are the city manager of the City of St. Joseph, Missouri.
Yes, I am.
Are you the same Brian E. Carter who caused to be filed in this case direct testimony, which has been pre-marked as Exhibit 850, and sir rebuttal testimony, which has been pre-marked Exhibit number 851?
Yes, I am.
And if I were to ask you the same questions today as are asked in those exhibits, would your answers be the same?
Yes, they would.
And the information contained therein is true and correct to the best of your knowledge, information, and belief?
Yes.
Your Honor, I offer Exhibits 850 and 851 into evidence and proffer the witness for cross-examination.
Thank you. You've heard the motion by counsel for the admission of those two exhibits. Are there any objections? Hearing none, Exhibit 850 and 851 are admitted onto the hearing record. The witness has been tendered. According to the presiding officer's cheat sheet, that takes us to Mr. Kleiser.
No cross. Thank you, Your Honor.
Staff? No questions, thank you. And the company.
No questions, Your Honor.
That will take us to commissioner questions. Are there any commissioner questions for Mr. Carter?
Not at this time, Judge.
Thank you, Commissioner Holzman.
Not at this time.
And the bench has no questions. Thank you, Mr. Carter. You are excused. I appreciate you traveling all the way and supplying your testimony and being here. Sometimes that happens and there's just no questions.
I appreciate the commissions and Your Honor's time. Thanks.
We are at the end of our day and we have one optional witness. Are any commissioners interested in any questions for Ms. Sarah Lange of staff? She's being offered as a witness.
No questions at this time, Judge.
Thank you, Commissioner Holzman. The bench also has no questions. I'll go ahead and ask the parties just to make sure. Any questions by the parties? I'm only seeing shakes back and forth of the head indicating a negative. Let's move on. We are done for the day. Before we go off the record, the only announcement I can think of is that we start tomorrow at 8:30, and we will be followed after the conclusion of testimony in the evidentiary hearing portion. We will then proceed after or at 1 o'clock, the sooner of, going to the on-the-record presentation regarding the 4 stipulations that we have received so far.
I believe this might have been mentioned earlier, but to the extent that people need to join the WebEx, is it the same WebEx?
It'll be the same WebEx for, obviously for the hearing. And yes, excellent point. Same exact WebEx. It will remain open throughout the entire day as it has been. So we in the room will really be the only ones kind of transitioning from one thing to the next. Okay, we are adjourned. Off the record.